All right, ladies and gentlemen, welcome to Senate Judiciary. It's about 8:30, maybe a minute or two after. Let's go ahead and get started. Kylie, will you call the roll?
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, and Senator Barfoot.
Here.
8, and we have a quorum.
All right, we have a quorum. Thank y'all for being here. As I said, first meeting of Judiciary, so let's start it off with SB 24, Senator Weaver.
Thank you, Mr. Chairman. Today, I am here to talk about a bill that would increase the penalty for false reporting. Many of you are aware of a situation that happened in Hoover last year, and I've had a lot of feedback from the public with overwhelming support for stricter penalties for false reporting. The bill that I'm bringing today, we've had a lot of discussion over the past year, and I believe it's a very fair place to start. If a violent crime is alleged or a crime that would threaten the public at large, you're going to have a very significant police response, and we think it's important that the punishment be higher than a misdemeanor. So we created this bill to make that a Class C felony. We also have outlined the issue related to restitution as well.
All right, members, any questions, comments, Senator Bell? Got a motion for favorable? Got a second by Senator Stutz. Got, is that a second down there, or is that a question?
It's a question.
Question, yes, sir. Go ahead, Senator Albritton. I'm working on it. Only 6 years into it.
You're getting there.
Getting there.
If I might, Senator Weaver?
Yes, sir.
This deals with just criminal aspects. I mean, what about the issues that are false claims possibly made in civil matters?
So this is a false claim that only alleges imminent danger to a person or the public. It depends on the level of
Does that include domestic violence matters?
So it depends on the response that it initiates, and certainly we've had those discussions, and we believe that this is a fair place to start. If it's something that's domestic that is able to be handled at a lower level of response, that's certainly something that would be a different situation.
My point, if I might, is in domestic matters, if there's a claim made in domestic that there's a violence, a threat, or whatever, that's certainly a threat to an individual. And very often that happens, and there's an ex parte hearing that occurs, no evidence is presented, and yet there's certainly effects that go to the other partner, and there's no finding or there's no challenge as to whether it's valid or not valid until it's a very subsequent after. I see Senator Gavan nodding. I think he understands where I'm headed with this. My question is, does this and will this apply in that circumstance?
So again, I'm happy to talk to you. If you say yes, I believe that it would. If there's something that elicits this huge police response, the situation that I'm referring to. Where
domestic violence call is inherently dangerous anyway, and in this circumstance or whatever, the concern is twofold there. One is the false reporting, which I think is extremely common, and the second is, does this have a chilling effect on making valid claims?
Let me see if I can maybe
You don't like my question?
Well, I'm going to try to. This is the way I read it, because I had been, there were some concerns about that too. Existing law already relates to, there's already existing law out there as it relates to false reporting. This just classifies that it could be a Class C felony under certain conditions. So I don't think we're carving out or making an exception or treating a domestic violence situation any different unless it rises to this level here. That's the way I understand it, to where there's imminent danger to a person or the public. So
So it's a potential that it could apply, but that application would depend upon the facts.
I think that's true, fact-driven, as whether it's a domestic violence situation, whether it's
How do you deal with that with an ex parte hearing?
well, at an expert, and I don't do the domestic side of that equation, but certainly on a criminal case, I mean, the DA's office would have to prove beyond a reasonable doubt, or the city prosecution, I guess, the DA's office, since it would be a Class C felony, would have to prove beyond a reasonable doubt. You're afforded an opportunity to go
So
through.
what is domestic violence, though, then? Is that criminal or is it civil?
Well, I think it's both, depending on the type that you have. But and also there are misdemeanor criminal offenses and there are domestic violence offenses, and there's certainly some that rise either because of the effects or what's happened during that incident, or because of the prior DV cases to make it a felony. So I don't see this as being something that. I mean, it is fact-specific, according to the legislation, that, if there is imminent danger to a person.
I don't have a problem. I'm not going to hold it up. I would like to discuss with the senator, the sponsor, after we get it beyond here, before we get it to the floor.
Senator Coleman Madison, and then next will be Senator Figures.
Thank you, Mr. Chairman. I kind of see where Senator Albright is going, but I'd like to.
Did you say I was right?
I didn't say you were right. I said I kind of followed your thought pattern. Yeah, and really it could affect a lot of people. So I just want better understanding, and I wish if you kind of give me an example of that, because we see a lot of that in the communities and things like that happening, and I don't want to add an additional burden, but I do want to ask Senator Weaver. Page 3, section D, subsection D. Explain what you mean. It's a term of imprisonment posed by a felony violation of this section shall be served day for day, shall not be reduced or suspended by provision of law. Can you tell me what that, I mean, I know we got a lot of attorneys around. I'm not.
And so actually, I had
represent the
worked
lay
with
people.
Senator Bell on that specifically, and if it's okay, he will help explain
Okay.
that part, since he and I had worked on that a lot together.
I think in most cases, you get a suspended sentence. You may get, like, if it's, say, the Class A misdemeanor, a municipal judge will give you 180 days suspended, 2 years unsupervised probation, and do that. If it's a felony, then also the judge can give you, 2 years suspended and go on. This requires there's no suspension of the sentence. The judge cannot suspend the sentence. What they give is served day to day, and there's no suspension of the jail sentence, so that if you make this and the resources are expended and you're claiming they're imminent danger, that you actually serve some time in jail instead of getting a slap on the wrist. I think that was what I read into it when I read it.
Define imminent danger again according to your bill.
So it's something that makes this huge police presence go out. This in this situation that we were given as the example, the police got the report. They believed that this young woman was in danger. They believed that a toddler was in danger. Their situation was an imminent danger that then caused all this huge police response.
I don't ever recall them saying that the police was in any danger.
Oh, not the police, but the people. They thought that the kidnapping victim and the toddler were in imminent danger.
Mr. Chair, there's another issue that brought up.
Let me Senator Figures had
Okay.
a question or comment first, I think.
Thank you, Mr. Chairman. I think that's a little excessive, this day-to-day thing, because there are other crimes that are so much more excessive than this that doesn't happen. So, but since you are bringing this legislation because of that particular incident that happened, I think you should simplify the bill to deal with just that. When a person is reported, and there are a lot of resources that go out in terms of trying to find this person, whether it's with the aviation part, whether it's with the marine part or land part. So I understand that, but I think you should make it specific to that.
So let me clarify this.
And then in that way, Senator Albritton's question, it wouldn't confuse any other probable actions.
So this will not have an impact specifically on that case at all. This law will go into effect after all that is been resolved.
Oh, no, I know that. I'm not saying that. I'm just saying that you said you brought this bill as a result of that particular incident. And that's why I'm saying if that's what you're trying to alleviate or bring penalties and jail time to a person for doing that to try to keep somebody from doing it, then I think you should make this bill specific to that act. But I still think that part about day-to-day is excessive for this particular.
Again, the situation did open our eyes to places that we believe we could make the law better, and happy to have those discussions with you to work some of that out.
Senator Albritton and then Senator Singleton.
What we have here is a potential, especially as Senator Bell brought up, this is a suspension. Whoever gets convicted of this going to jail. Is that a fair statement? Jails that we don't have, all right? We don't have anything. We're trying our best to build, but we ain't got some yet. And this is going to have an immediate effect of immediately sending more people to places that we don't have places. So that's one concern. But look at what the effect that this could be, and that is a nasty divorce, domestic matter, claim made of threat. Oh, somebody's here, and they pick up the accused or have an ex parte hearing before they pick him up. The ex parte finds that he is a threat. Now what happens? With no evidence other than a claim, no hearing, he goes to jail for 2 years. That is a danger, ladies and gentlemen, that is real. It actually is happening now, and I think this will exacerbate a problem. That's my comments.
I think the way I interpret your concern is just the opposite of what the bill is trying to do. It's not the person who has been accused of an event or a crime that would bring out. It is the person who makes a false accusation of that. So,
assuming that this falls into the false accusation, that talk about exacerbation, let's assume that that is because it's nasty. She wants to get rid of him, or he wants to get rid of her. The claim is made, and again, it doesn't find out whether it's false or not until the guy gets out of jail 2 years later. I think we're heading toward a problem.
Senator Singleton, did you have I think I saw your hand.
I had something similar to his line, and I guess I'm trying to look for the intent in this. Where's the intent? We're just talking about people making accusations. And if there's no intent to do that, what if someone who may legitimately feel that someone is missing and they're trying to get in, people go out to search and feel that they're in imminent danger, and it ends up being a false report or something, and somebody want to prosecute them based under this because they see that we now have that law to do that.
This is something that Senator Bell and I have also worked alongside with that.
I think Safe Senator Albritton called in a report that I kidnapped him, and I'm holding him against his will. And you have all the authorities here come and they storm the State House. They're looking around, and in reality, all I know is we've gone on a little trip. I don't know anything's going on. He's expended a lot of resources for making that claim. And all this is moving that from a Class A misdemeanor to a Class C felony. The law already existed. This is just changing the punishment, is all it is. To give the judiciary. And I think when they looked at the one what happened in Hoover, and how many days after days after days they spent, you had federal authorities, state authorities, local authorities, and the amount of resources, man hours, officers never going to sleep. They worked on that nonstop. And I think this just when they found out what she did, that it's just a misdemeanor, it was more of a slap in law enforcement's face. And I think that's what this moved is, to where there's more punishment on it. And I think that's the basics of
Make her pay restitution. Make her pay restitution. If that's all they lost is some time, make her pay restitution. It's not like nobody out there was hurt or they got in imminent danger trying to find her. They do search and rescue anyway. That's their job.
I understand, but people won't even pay court costs these days.
Yeah.
I mean, so getting restitution when you don't have the money. I couldn't pay the restitution what this probably cost for the, Hoover, the state of Alabama, Jefferson County, the other counties. I think Shelby County was involved. All the counties that were involved, I couldn't pay that amount of restitution. So I think the restitution it is great. I agree, but they would never recover that.
If I may give one real life example of why I'm so adamant here, may I?
Yes, sir. Go right ahead. And I think Senator Coleman Madison, did you have another comment there?
I do, if you would.
Let me give my example, and it may, all right. This came this weekend, a friend of mine, grandmother, gets a call on her phone, her grandkids, which is common, come get us, please. So she travels the 5-6 blocks to the other apartment where the grandchildren are to pick them up. She gets there, and the mother of the children storms from another place and attacks her verbally, makes accusations, and files a complaint against the grandmother, who is subsequently picked up, arrested, and made go on bail. She was never on the property. She never and responded to a typical thing. Is that a false accusation?
No.
They don't fall into
And it
it?
requires intent also. I mean, it's knowingly, the intent is knowingly.
Wasn't that the knowingly intent of the mother to do something? That's an argument. The point is that an ex parte hearing found guilt. My point is we're into some dangerous.
It only is.
Senator Coleman Madison.
I still have an issue with this, the imprisonment and no suspension. I agree with what you're trying to do. That whole case scenario was just appalling that somebody would do that. But I don't think this is the answer. Looking at the situation, I mean, let's face reality. The answer to crime of this nature is not necessarily locking everybody up. If that's the case, I mean, we're going to have a lot of people that's going to get caught in this net. I'm hoping that we can find something else that's a punishment, that's a real punishment as a deterrent. But locking them up and putting them in jail with people who are really criminals, that's really committed a heinous crime, I don't think this is the answer. And for that reason, I can't support it, because I think people should be punished for these types of crimes, but I don't think this is the answer. Going back to what Senator Albright has said, the prison's going to be full. You're going to have a waiting list to get in. I don't know where we're going to hold them. Maybe we'll put them in some kind of, I don't know where you're going to put them. But they'll be full based on this, because there are a lot of people that I think you're going to find the people in domestic violence that's going to, again, like you said, it's going to fall into this. But I don't think the punishment fits this particular crime. However, I do think there needs to be some punishment, but I think we need to find one that really fits it. And I don't know what that would be. Maybe it's community service, maybe it's working in the situation, I don't know. But I don't think that crime would rise to this type of punishment. The punishment doesn't fit the crime in this case. And we're basing it on one case, but this law will have a net effect that will be thrown out and catch a lot of people into it. So while you're basing it on this one incident, have you thought through other things that might come up based on this law and people that will fall into it?
Yeah, we've had a lot of discussion over the past year, and again, we don't believe that the misdemeanor is the appropriate punishment for this. We hope that with the law like this will deter others from doing what happened in Hoover.
Yeah, but the end result of the impact on state resources and facilities, and how can we really enforce it? We don't need to be in another lawsuit or a federal intervention with our prisons, because we cannot house these people. The counties have already told them, state, get your prisoners out of our county facilities. We don't need to be creating another problem for ourselves. I agree with your concept and what you're trying to do. I just think we need to find a punishment that fits it and does what you want to do as far as real punishment for this crime.
I appreciate your comments, and I'm hopeful that this legislation will deter people from doing that, so we won't even have to be in that situation.
All right, got a first and a second. Holly, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison?
No.
Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton?
No.
Senator Smitherman? Senator Stutz? Senator Weaver?
Aye.
Senator Barfoot?
Aye.
9-3.
All right, Bill's given favorable report. I'm going to address SB 89 was on there. That was Senator Smitherman's. He's asked that that be carried over. Up next, we have kind of a different situation. I'm not aware of this happening in the past, but SB 93 by Senator Chambliss and SB 18, we've had two senators that have been working on the same piece of legislation, and so we're going to get an opportunity to hear from them today, both. Senator Chambliss, if you will come up.
Point of personal privilege, Mr.
Yes, ma'am.
Chairman. So SB 18, I know my numbers, 18 comes before 93, and they are and I looked at this as I read it last night, I'm like, the order, why would it be put first? Because, I mean, you know, if 93 goes and it's passed, what's the point of 18?
I'll tell you why it's on there the way it is, because I had a conversation with Senator Coleman yesterday, and I agreed to add it based on that. We'd already had the agenda set, so
But-
we'll be able to hear from Senator Coleman today. Senator Chambliss?
Okay, but again, sir, with all due respect,
No, we intend to take both of them up today. Senator Chambliss.
Thank you, Mr. Chairman, committee. This bill came about as from two contacts that were made to me directly, so I started working on it. It deals with the federal class action lawsuit with the Boy Scouts, and in the state of Alabama, the way I understand it, the victims in Alabama are not able to participate in that settlement because of our statute of limitations. So what this bill does is to try to very, very narrowly allow those that are participants in that settlement or victims from that court case to be able to participate in that settlement. I wrote it very, very narrow to that, not to open up to other issues and that kind of thing. When I did I introduced the bill Tuesday and approached the chairman about getting it on the agenda, as I would normally do. And of course, he said, submit a written, all that kind of stuff to get on the agenda, which I did. But he also made me aware of Senator Coleman's effort on this same issue. So Senator Coleman and I don't know if she's in here or not. Okay. We did have a brief conversation yesterday. We have the same goal. What we have agreed to do, not to speak for her, she obviously can speak for herself, is to work together to move this issue forward. There is a time-sensitive nature to it. There is a deadline in April. I don't remember the exact date. But this has to be through the process and signed by the governor before that deadline, or they miss out on it altogether. If you've seen the fiscal note, it doesn't affect state, county, local resources at all. It's all part of a settlement. So with that, I can answer any questions, and certainly would love for you all to move both of our bills out, and then Senator Coleman and I pledge, and I think she will as well, to continue to work on this issue together in a bipartisan manner.
Thank you, Senator. Any questions or comments? Senator Coleman Madison.
I have a comment. So basically, these are the same bills as I looked at it.
Not yet, but I understand Senator Coleman will have a substitute that will mirror what Senator Chambliss is accomplishing. I know Senator Coleman and I'll speak to this when she comes up, been working for a long time. She has put a lot of hard hours and time and resources into her bill.
Okay, my comment is that maybe you all need to get together and come with one bill that y'all both jointly. And I don't know whether you want to do it alphabetically or go by the numbers here.
Well, we've got two bills on there. It's my goal to get both of them out and certainly let them work together to see who's going to be the sponsor on the floor. No problem. And I think you just heard Senator Chambliss said he will continue to work with her and see where that goes. So
I don't know. I see a little inequity here, but go ahead.
it's Senator Albritton.
I'm a little bit confused. This, first off, this is dealing with retroactivity.
Correct.
Going back to a time frame in order to, well, anyway, and it's dealing with bankruptcy proceedings. Evidently, that's ongoing. Is that correct? There's a target here. That's what I'm getting.
That's correct.
Who's the target?
The Boy Scout organization.
Okay, Boy Scout organization.
Correct.
All right, and this is dealing with sexual crimes as defined at a particular time frame that occurred and such. So it's a matter of trying to reach, folks are trying to get in and get a piece of the pie, so to speak. I don't mean that in a derogatory matter, but this is about money.
Yeah, compensation for their being a victim.
My question is, in these circumstances, has there been a finding of guilt or innocence or of wrongdoing by an individual in this time frame, or is this simply holding the entity responsible without any conviction of any individual?
It's my understanding that there is a federal class action lawsuit that has been settled. An award has been made by the court under certain circumstances. In the state of Alabama,
Suits that we see on TV, if you've been injured here, give us a call.
I don't think I would put it in that same category, but
I'm not doing it very well, but this point is that it's a settlement and there's money there, and there's a means whereby injured parties can come in and be who decides whether the party was injured or not is what I'm trying to get to.
The federal courts.
So the federal court would hold a hearing on the claim and a finding of guilt or innocence?
I believe they've already done all of that.
But if it's, that's what I'm confused about. Because the statute of limitations is 6 years after someone turns 19, we could have people that are 50 and 60 years old making these claims. Is that correct?
That's correct.
And I think there's a sunset provision on this, which would allow those people who have been injured and are contemplated as victims in that settlement and could thereby try to access those funds. Again, I think it's, as I understand it, there is a set aside amount by the court system, and there are certain individuals who are enabled or have the ability to, but unless we change this the way your bill was and the way Senator Coleman has worked so hard to get done, that the people of the state of Alabama will not have access to that. It's not a quote piling on. It is, there is a pot of money there that the courts at the federal level have said, if you fall within these parameters, you will be able to receive that compensation under this fund. And we need to do this to allow the citizens of the state of Alabama that access to that. So
that's correct. You're correct, and it does have the sunset. Also, there are people in the audience here that are part of this class.
Right.
And it is my understanding that the Alabama, all 5 regions or districts, whatever, I can't remember what they're called, all 5 of those Alabama regions of the Boy Scouts support this bill.
Okay, thank you.
My only question is, who finds that wrong or that damage has occurred?
I think it's just like any class action settlement, either by agreement of the parties or at the federal court level. That's been a determination that's been made. That's my understanding. We got a first by Senator Bell, a second by Senator Gavan. Holly, if you'll call the roll.
Senator Albritton?
No.
Senator Bell? Senator Cornley? Aye. Senator Coleman-Madison? Senator Elliott? Aye. Senator Figures? Aye. Senator Gavan? Aye. Senator Orr? Aye. Senator Singleton? I will not a reservation. Senator Smitherman? Senator Stutz? Aye. Senator Weaver? Senator Barfoot?
Aye.
Favorable.
Bill's giving favorable report. Thank you, Senator Chambliss. Up next is going to be Senator Coleman, SB 18. Senator Coleman, I know you have worked tirelessly on this for a long period of time. We've had several meetings in the off year to get us to this point.
Yes.
You have called and bending my ear and
Yes, I
twisting
have.
my arm.
Yes,
and
I have.
We are here.
Every bit of that.
Tell us about. Senator Coleman, if you will, tell us about your bill and what you, I don't think that's true. Let me tell you why I don't think it's true. Because Senator Chambliss in the past week told me he had a bill, as he told you that he did. Senator Coleman and I have been working tirelessly. I didn't get a request until yesterday. I think that was a mix-up or confusion between us. But as soon as that request came in, you know what happened? As soon as that request came in and we talked about it, she's on here. So, Senator Coleman.
Thank you. I will say that the chairman did accommodate, and I know there is no public hearing on this particular piece of legislation today. I think Senator Albritton may be talking a little bit more about the Senate Bill 19 that I have, which is the larger version of this bill with the revival period. This Senate Bill 18 is specifically to allow the nearly 2,000 victims of child sex assault that from the Boy Scouts to have access to that national trust fund. So this is the streamlined piece of legislation. You do have a substitute in front of you that mirrors Senator Chambliss' bill. My version of the bill is a larger version of the bill that is modeled off of Ohio. That is the bill that Senator Barfoot and I, along with the independent insurance agencies, had been talking with about in the interim. And I thank them for the opportunity. If you remember last session, we actually did have a public hearing. We had some impassioned pleas to the committee to pass out the larger bill, the revival bill. But this is a time-sensitive issue. If we do not pass this piece of legislation with that substitute, and Senator Chambliss did mention, we talked on the floor yesterday. He was not aware of my bill. I have been working on the larger version of the bill for about 3 years now. Was contacted by survivors. We have some of them in the audience today, the Alabama survivors of child sex abuse. And if the committee would oblige, I would love for Stuart Vance, if you would oblige, just to have a brief moment to say something to the committee about the urgency of this issue.
Do this. Let's get the sub in position. My understanding from what you've said that your sub mirrors
Yes,
word
sir.
for word what Senator Chambliss and what we just voted on. Entertain a motion to adopt the sub. So moved by Senator Figures, second by Senator Coleman Madison. Let's do the long roll. Any opposition to the bill being substituted? Hearing none, the bill is substituted. No opposition to the substitute. All right, then it is unanimous that that bill be substituted. Senator Coleman, I think you did mention that now we're on the substituted bill.
Yes.
You want to have, I know you've got some folks here that are very
Yes.
passionate about it. And I hate, with passion, I hate to limit time, but in the interest of
Just
time.
one person.
That's fine, absolutely great.
Mr. Vance, can you come forward, please, as a representative of the group? Thank you. And that was brief.
Thank you, Senator Barfoot and senators. What I'd mostly like to do is I heard Senator Albritton ask a number of questions, and I'm in a pretty good position to be able to answer them. I have studied the scouting settlement and have a pretty good understanding. While was not a scout myself, I am a survivor of child sex abuse. And to answer your question about who determines what in this case, so 82,000 scouts nationwide have filed claims against the Boy Scouts. And what ended up happening is the Scouts underwent a bankruptcy. Between them, their insurance companies, and a number of church groups and organizing groups around the country that have sponsored the scouting troops, they set aside a pool of $2.46 billion. That money is in a bank sitting there. So far, about 3,000 men have been paid about $8 million out of that pool. When you applied to the pool, when you filed a claim, you had two choices. You could either take a one-time $3,500 lump payment and be done with it, Or you could ask the bankruptcy administrator, the settlement trust administrator, to adjudicate your case and come up with a number. The max benefit that you can get is $2.7 million. And for some of the men who suffered repeated abuses by multiple scout leaders, $2.7 million is pretty fair compensation. But the trust administrator...
I disagree with you. I'd say it's not enough, but...
Agreed. The trust administrator will adjudicate each of the claims. Now, there's some kind of weird things about it. If you want a larger settlement, you actually have to pay, as a survivor, $10,000 to the administrator to have them investigate your case thoroughly. But at that point, a $10,000 investment for, potential $2.7 million payout, for some people is worth it. For others, they can't afford that. So they're going to be getting what the administrator says. And the administrator is a retired judge who was put in charge of this, much like the 9/11 administrator was done. So this does not cost the state of Alabama any money. This does not cost any organization any money. It is just allowing the 1,500 to 2,000 scouting survivors in Alabama to be able to fully participate and not just get pennies on the dollar.
Because if we don't pass it, they'll just...
If we don't pass it by early April, then basically they are left out. And that's why, while I applaud Senator Coleman and Senator Chambliss to work together, time is of the essence. We have about 4 to 5 weeks to get this signed by the governor. And if we don't get that done, then these men are going to lose out substantially. And I can tell you, we've got 3 of them in our group of survivors. And
let's get busy.
It's heartbreaking to hear.
Let's get busy getting this bill out as well.
If you have any other questions, please let me know either now or afterwards. I'm happy to stay and talk, but thank you for your time.
Thank you. Got a motion for final approval. Senator Bell, favorable, and Senator Weaver, I second that. Any opposition to using unanimous roll that we had before? Senator Albritton will be marked as a no on that.
Yes, may I have him just explain one
Yes, sir.
I'm not insensitive to the needs. I'm not insensitive to what the difficulties are. I'm acutely aware. My concern is whenever we start dealing with the legal aspect of statute of limitations, which is there for a reason, which is there because of evidence, of being able to have true and concrete evidence involved. And that's why the statute of limitations are there, to provide a protection. So,
and I don't want to belabor the point before voting. I just want to recognize that in these survivors of child sex assault, why we are asking for, even in my other bill, the extension of the statute of limitations is because many of them they're not able to talk about it until they are well past the statute that is passed. Many of them are not even able to talk about it. The studies tell us it's about 52 or 54 years old is when they're actually talking about it and revealing it. And so that's a whole nother bill. Hopefully we'll get a chance to talk about that later, but I would ask the committee to pass this bill as substituted and give it a favorable report.
I think we just did. I think it was unanimous.
Oh, I missed it.
And I don't know where Senator Albritton, what was your ultimate? Okay. Okay, all right.
Thank you, Mr. Chairman, for accommodating, and thank you for championing this issue on my behalf today, Senator Coleman Madison. I didn't know if I was going to make it, so thank you so much.
Thank you for your hard work over the off season and probably before I even knew you were working on it. All right, next bill up is Senator Orr. Senator Orr, if you will, tell us about your bill, SB 57.
Thank you, Mr. Chairman. Members, this is a bill we passed out last year, passed out of the Senate, passed out of House committee, and then ran out of time. It comes from the protest outside of Justice Kavanaugh's house in 2022, and it seemed like it's kind of a new era in going to people's houses to have your protest with bullhorns and large amounts of people gathered. And so that's the reason I filed the bill last year. Here we are again. And, as we look at our society, you have to think, what is on the books? Now, this bill allows for the locals to bring in whatever local ordinances they want, which would could be replace what the state bill does and control what they want to do. But a lot of cities, they do have noise ordinances, or you have to get a parade permit to march up down the streets. But to go to someone's house and then plant yourself and be on the sidewalk, not trespassing, can really create a problem. The bill does not apply just to public elected officials.
Move a favorable.
It could be anybody.
We've got a motion, but we do have a public hearing that's been.
The only other thing I'd say, imagine if you are in your home and you've got 50, 100, 75, whatever it is, people that are mad at you outside of your residence. You don't know them. You don't know if they're going to shoot through the house, throw a Molotov cocktail. You've got children. You want to leave. What if somebody has to go to the doctor? They're all crowded around your driveway. How are you going to get in, get out from your home? So I do have an amendment. I talked to the lady who called the public hearing who had concerns about putting more definition around the bill. I concur with her concerns and do have an amendment, Mr. Chairman. Also, I'd like to circulate to the committee members.
Okay, let's go ahead and while that's being circulated, let's go ahead and have some discussion, the public hearing. We've got two opponents signed up today, Kai Davis, Project Say Something, and Kai, are you here? If you could let us know your name, something about, tell us why you're opposed to it, and we're going to limit public comments to 2 minutes apiece.
Good morning. I'm Kai Davis, the Comms and Networking Director for Project Say Something. SB 57's context, or lack thereof, raises a number of questions for the activist community. Specifically, how is a residential area being defined? There's no context on this in the bill. And to what end is a residential area to be considered? Are we including parks, churches, schools, community centers? I mean, if you take Florence, Alabama, for example, where Project Say Something protested for 26 weeks to the downtown area to have our Confederate monument removed. Like many cities, Florence loves to put a home in a convenient and accessible area. It's good for the city's economy. There are residences all through downtown, even on top of commercial businesses. So what is a residential area? There's no context in the bill on this as it is. I'm wondering who is even going to determine what is to be considered a residential area. Is it the sponsor of the bill? Is it the local government? I don't know, because there's no context on that in the bill as it is. Is there a specific distance from a residential area deemed acceptable to protest? There's no context on that in the bill as it is. I mean, how would these noise ordinances even be enforced? There's no context on that in the bill as it is. Now, I know a lot of people in front of me are ultimately looking to pass SB 57, but as an activist, these are answers we need in order to do what we need to do in a legal and respectful manner. I almost get it. The point is to be annoying, but, trying to regulate our voices, we need some sort of guidelines further than the vagueness that has been given in the bill. So we're just asking that you revise it, just take a step back, and then, just give us some more clarity. So I'm not saying vote no forever, but at least for right now, before y'all pass it to the House, please just look back over it.
Ms. Davis, you bring up some very good legal potential issues, and I'm hopeful that, especially with the residence area, that there may be an amendment for that, I believe. Right. So if we could go ahead, and before we address the amendment, we also have Mr. Travis Jackson, Black Lives Matter Grassroots.
Mr. Chairman, did they get a copy of the amendment?
Yeah, I got a copy.
Okay. Yeah.
You got Ms. Jackson.
Yes, thank you, Chairman and members of the committee. My name is Travis Jackson. I am a concerned District 30 Alabama citizen. I'm also an Iraq veteran and as well as a trauma survivor from what I've witnessed while advocating for racial and other sorts of social justice. I am in opposition of SB 57 because I believe that it is a destructive bill towards Black, Indigenous, and people of color exercising their First Amendment rights. Many nonviolent protesters in general have been and still are throughout American history are targeted criminally by law enforcement. The majority of the people who are targeted by these erroneous acts are Black, Indigenous, and people of color. That includes the Hispanic, Latino, and Asian American community. On numerous occasions, I have witnessed how police officers have violently binded both nonviolent protesters' hands and feet, apprehending them like dogs as they were exercising their First Amendment rights. Prime example was Hoover, Alabama in the summer of 2020. Also in July 2020, I witnessed Hoover police officers were armed with assault rifles as nonviolent protesters were exercising their freedom of speech. That was also in Hoover, Alabama. From fall of last year till now, the Decatur police has strategically, unlawfully arrested nonviolent protesters whenever they brought awareness towards Steve Perkins, who was ambushed by police and a tow truck driver in the early wee hours of the morning on September 29th, 2023. My question is, why are lawmakers not passing laws to address the use of tear gas, rubber bullets, as well as false criminal accusations on nonviolent protesters? SB 57 is just as hypocritical as the police slogan, to protect and serve. American history has proven for decades and centuries white extremist groups like Sons and Daughters of the Confederates, Three Percenters, and Patriot Front are the only individuals protected by America's justice system.
Mr. Jackson, thank you for your time. I know 2 minutes is a short period of time, but we do appreciate your comments and appreciate you being here. Senator Orr, if you would explain the amendment that the committee has.
Right. So the amendment, and I was talking to the gentleman from West Alabama, I'm certainly open to continue to work on this, but it gets into the noise part of it there, and then the timing, the sunrise and sunset, and Section C, blocking the ingress and egress of the facility. Again, this is a Class C misdemeanor, which is they figured it out 5 minutes ago, 3 minutes ago.
Senator, or if you look at it, it just say Class C, it doesn't say misdemeanor.
Well, that's in the original.
In the original,
yeah,
okay.
Yeah, it doesn't change that. Then they, are to be warned to disperse, and then it's up to the locals at the end of there on page 2 about municipals and counties can do something more stringent, but that's their business. This is a more of a less a catch-all. And like I said, I'm open to if people got good ideas. I hear the opponents on the apartments, and Mr. Latham and he's working on that on the urban environment.
Okay. Members, any questions, comments as it relates to the amendment?
I'd move move adoption of the amendment.
Got a motion to adopt the amendment.
I have a question on the amendment.
Got a second on that with Senator Weaver, and Senator Figures has a question on that.
Yes, sir. Thank you, Mr. Chairman. On page 2, where you do give the municipalities and counties by ordinance a resolution to adopt more stringent regulations to limit the time frame, I think I don't agree with that, because you will have some locals who would, I think, abuse it. And I think a state law period should be where it ends.
I'm willing to discuss that if we want to.
But if you adopt the amendment, then it's no time to discuss it.
We can we can table this amendment if we want to discuss that and do a new one on the floor.
Is that your motion to table the amendment?
No, I want to go ahead and I'd like to put the amendment on and then continue
you're saying
conversations
that,
with.
you know that would never happen.
That's not true.
Tabling it on the floor,
Yeah, that's not true. We do it all the time.
Senator Coleman Madison.
if you're for it.
If I'm what?
If
I was just trying to accommodate the locals, Senator. You know, that's on my
that may be part of
on
the
my
problem,
on my
depending on which local
on
it
the
is.
baby formula bill. You know, I know you're accommodating the locals there, but I mean, let's.
Wait, let's, since you brought that up, let me clarify that.
Okay.
Since I have been in this Alabama State Senate since February 4th of 1997, I have always said that the cities and the counties should be the one to make the decision whether or not they exempted their sales tax. So that was nothing new for me. Of course, I accept it. I'm just glad you guys caught on to it.
Senator Coleman Madison.
I have a question, and I don't necessarily have a problem with local municipalities because some of them, and I use Birmingham as an example. Why are you looking surprised over there?
I'm not. I'm just trying to listen.
Okay. Birmingham already has a noise ordinance, so I'm wondering how this is going to impact if it is taken out. If it, you know,
stricter.
If it's,
They can do something stricter. They can take it.
This was trying to be kind of a catch-all
okay,
in
yeah.
case they didn't have anything, but if they wanted to have something different, then.
And the reason I agree with the concept because cities are different, counties are different, rural areas are different. You may be in an area where you don't have a lot of houses around. In the urbanized area, you have people living in downtown. So that's why you have mixed use concepts where you got businesses and residential that are together. So it's going to be kind of hard. You may be picking in a business, you know, but is this about a business strictly residential?
Strictly residential.
Well, but again, and I don't know if you want to try to pass this today, but I mean, business and residentials are in together, and that is a going trend right now.
Oh, mixed use.
Yes, that's why they call it mixed use. So I'm just wondering how this is going to blend.
Well, that's what Mr. Latham and I are still trying to come up with what's plausible in that situation.
So are you trying to get this out today, or are you
Yes.
trying to get it right?
I'm trying to get it out today and continue working on it.
Well, I hope we don't try to do anything because this really could have far-reaching impact unless we get it right. You know, we don't want to limit people's freedom of speech.
No.
However, I do understand and see some significance in it. You know, somebody may be picking in my house, but my neighbors, you know, it's going to be offensive to them. So I can understand that. But I just wanted to make sure we are trying to be fair about this and not limit a person's freedom of speech.
Senator Singleton.
Yes, and I think Senator Orr, the discussion that he and I had a problem with this in the bill to say no person should pick or process at or near, and that is totally undefined. What is at or near could be very subjective, but he did explain to me that they were working on that because when we talked about in an urban area, in terms of where you were, row houses or apartments that sit above other businesses, it could mean differently and could be subjective from a neighborhood versus in an inner city.
I
We're
think
going to try to get some clarity.
Ms. Davis, I think, brought up a very good point on that about some legal definition
The
there.
problem is if you get 30 feet from the door, 45 feet from the door, the door is many times closer than, so now you have a zone that's maybe out on a public street or something. So you get, not all doors are equally away from the street than others. I mean,
I know
some right up on the street, some, it gets confusing.
All right, we had a first and a second. Any more discussion on the bill itself, on the amendment? I'm
You're
sorry.
willing to work on it, though.
Absolutely. I said that at the outset.
Any more discussion on the amendment? All right, Holly, if you'll call the long roll on the amendment.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton,
No.
Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye. The amendment is adopted. Now on the bill, I'd make a motion for a favorable report. Is there a second? Second, Senator Weaver. Any opposition using previous rule? Senator Coleman Madison, you would like to be a no on that. Is that correct?
abstain on it because I want to see what the final product is.
Understand?
Then no.
Okay. All right. Bill's given a favorable report. That concludes the judiciary meeting. We look forward to seeing you next week. Thank you for participation, members.